I now come to the next theme, which is about courts controlling the media. So, what then of contempt of court? One senior lawyer termed the practice of the law of contempt in India as an instance of the paradox of the love hate relationship between the press and the judiciary. They need each other, but the judiciary would like to tell the press where it gets off. Beer Biceps wasn't expecting that with the court protecting him from arrest, it would also admonish him to behave on his show. Thankfully, the court self-corrected. It is not unusual, though, for the court to tell a politician while granting him bail that he will not address meetings and so on. The Supreme Court does have a system of accreditation of journalists for the print and electronic media. But then in the age of live streaming, live tweeting, there are numerous news purveyors, not just journalists. In fact, if one visits the press room today in the Supreme Court, you will find journalists watching the monitor rather than jostle for space in a crowded courtroom to report on the happenings. The press has to watch out for contempt action in two contexts. One is interference with court proceedings, and the other is scandalizing the court through personal attacks on the motives of judges, as opposed to critiquing the institutional performance. In the first category, that is interference with court proceedings, the earliest instance was the media campaign run in 1961 by R.K. Karanjia's tabloid Blitz in support of Colonel Nanavati, who was being tried for the murder of his wife's paramour. It turned the jury in favor of Colonel Nanavati. This led to the disbanding of the jury system in India. The Sahara case, the Nupur Talwar case, and more recently the Riya Chakrabarti case witnessed high-pitched shouting matches on TV screens of news channels, which were acting as prosecutor and judge. The guidelines framed in the Sahara case that an injunction could be granted where the reporting on a case might interfere with the right to a fair trial could be both overbroad and subjective. Judges in trial courts are vulnerable to intense public glare that the social media facilitates. It is necessary and prudent for judges at all levels to be cautious in engaging with the social media. Courts do cordon off trials from media, citing security reasons. Where the standards are vague, it is bound to have a chilling effect on the media, which then undermines the freedom of the press. The court has thankfully not yet placed restrictions on social media reporting on trials. After all, the criminal justice system is premised on public trials, and the press plays an important role in observing and reporting on the process. The second area where contempt proceedings could be attracted, the second area is of commenting on the court, its performance, its judgments, its judges. In the United States, the contempt power is rarely used by the courts against the press. In the United Kingdom, the Daily Mirror could get away with depicting the photos of 3 judges who granted an injunction in the Spycatcher case upside down with the screaming caption, "You fools." In November 2016, the Daily Mail on its front page depicted the photos of 3 of the judges of the UK Supreme Court with the caption, "Enemies of the People." That court had ruled that the UK government could not bypass Parliament to begin the Brexit process. Neither instance attracted any notice of contempt. Way back in 1978, in a somewhat similar vein, Justice Krishna Iyer postulated the Mulgaonkar principles to govern contempt proceedings. One of those was that the court will not be prompted to act as a result of easy irritability. Indeed, occasionally the Supreme Court has said that its shoulders are broad enough to shrug off ill-informed criticism. However, that is not quite how the judiciary as a whole has responded to public criticism. It has bristled with indignation. Arundhati Roy spent a day in Tihar jail for criticizing the court's muzzling of dissent over its judgment in the Narmada case. Patricia Mukim, the editor of Shillong Times, and her publisher were held guilty of contempt for suggesting that a judge had improperly acted in his own cause when on the day of his retirement, he passed a judicial order directing the state to provide retired judges with a slew of benefits. Apart from sentencing them to stand in one corner of the courtroom till the end of the working hours, Malott slapped a fine of 2 lakhs, loudly stating that this would shut the newspaper. Thankfully, the Supreme Court stayed the order. Recently, when Wikipedia opened a page on its website to report on the case between ANI and itself in the Delhi High Court, it invited from the Delhi High Court a notice of contempt. In an appeal by Wikipedia, the Supreme Court is reported to have questioned why the High Court was being so touchy about court proceedings. I now come to the last part. These are my concluding thoughts. It is clear that when the INB minister described Indian press as robust and flourishing, he could not have meant free and independent. The media in India has had to fight for its independence and for its freedom. It is a fact, though, that much of the mainstream print and electronic media are either owned by large corporate houses or by political parties. Both print and electronic media operate on purely commercial lines, dependent as they are on government advertisements, licenses and permissions, corporate sponsorships, commercials. These very media houses also have their corresponding web versions. As Joseph Pulitzer cautioned, once a publisher comes to regard the press as exclusively a commercial business, there is an end of its moral power. Self-censorship, paid news, advertorials, large self-promoting ads of governments on several front pages, vying for greater TRPs at the risk of fudging data are all now passé. There is also the control through sponsorship of the independent press on the net by corporate philanthropies. The big challenge then is to keep news free. Recently, I was sharing a panel with a senior lawyer who's also a member of parliament of the ruling party. The moderator asked us whether it was a matter of concern that much of the corporate-controlled mainstream media is aligned with the establishment. My fellow panelists' response was ingenious. They were exercising, he said, their free choice to align with the government. They could fearlessly report whatever the government told them. He was in plain denial that there was any muzzling of the press. For more than a decade now, the PM of the largest democracy in the world has not held a non-curated press conference to subject his government's performance to the scrutiny by the media, and yet there is but a whimper of protest. In his memoirs titled Hidden Agendas, veteran journalist John Pilger says that when Murdoch took over a newspaper, the reporters there would self-censor. They knew that some stories would never go past the editor's desk. Walter Lippmann warned that the threat to press freedom is not as much from pressures and intimidation that they face, but from those of their ilk that are readily co-opted into the heady mix of politics with the reward of proximity to the corridors of power. When asked to bend, they crawl. They might do well to heed Benjamin Franklin, who said, "They who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." While we find ourselves engulfed by WhatsApp forwards, which tend to hide the real news, not everything about the internet and social media is only troubling. It has provided space to journalists and influencers to speak fearlessly and carry their followers with them, free of control by state agencies. It has also provided such journalists with a two-way communication channel with a worldwide audience. And occasionally, tucked away in the corners of the print and electronic media, there is space yet for the investigative and critically analytical pieces of fearless and independent reporters, some of whom are being honored here today. Their courage and conviction will undoubtedly inspire generations of reporters. They need not just our admiration, but importantly, our support. They are our hope for a free and independent press, an impartial and trusted media in the India of the future. What is also encouraging is that they are not alone. Growing numbers of such independent scribes have formed global coalitions. The Panama Papers exposed a clandestine world of offshore finance and provided evidence of how heads of state, billionaires, celebrities, and business magnates used offshore structures to evade taxes, launder money, and conduct illicit activities away from public scrutiny. This was a result of a mammoth exercise undertaken by the International Consortium of Investigative Journalists, which brought together a diverse coalition of over 370 journalists from more than 100 media organizations across 76 countries to probe through 11.5 million documents. It tells us that even amidst threats and pressures, there will be those who are willing to risk their all to uncover and uphold the truth. As for the judiciary, it will have to develop the ability to receive criticism of its actions by the press, which performs the salutary function of holding it to account. Maybe the judges should recall what Lord Denning said in declining to proceed with a contempt case against Quentin Hogg. And this is what Denning said. Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity. That must rest on surer foundations. Nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it. For there is something far more important at stake. It is no less than freedom of speech itself. It is the right of every man, in parliament or out of it, in the press or over the broadcast, to make fair comment, even outspoken comment, on matters of public interest.